Right, hello everyone. My name's Alexander Ross. I'm a partner at the media and technology firm Wiggin here in London. And I'm actually originally a music lawyer by training. And like a lot of music lawyers and people in the music industry, I moved some of my practice over to the publishing industry. And I now advise a whole range of publishing and tech businesses, as well as music businesses and others. So we work very much in the commercial world. We work in the publishing world, as I said, but inevitably the vast bulk of the work we do is involved in commercial output by commercial businesses. And no surprise to hear that I'm a great supporter of copyright. And you might say, well, you would say that, wouldn't you? Because it's your work and it's your business. And that's true, and it earns me a living. But I'm a supporter of copyright for the very fundamental reasons that copyright exists. And I go back to something that Daniel Defoe said many years ago, as he pointed out with a plaintive cry, 1705, just before the Statute of Anne, one man studies 7 years to bring a finished piece into the world, and a pirate printer reprints his copy immediately and sells it for a quarter of the price. These things call for an Act of Parliament. And lo and behold, of course, there was an Act of Parliament 3 years later, the Statute of Anne, introducing copyright law to this country. Tristram Shandy made the same, in the book Tristram Shandy, of course, by Lawrence Sterne, made the same complaint, or rather the same plea. The sweat of a man's brow and the exudations of a man's brains are as much his property as the breeches on his backside. So, to my mind, copyright is there to protect the time and the effort and the investment in every sense in creating something new and original. Of course, in the commercial world, that investment is massive. I mean, we deal a lot in the film and TV business and the computer games business, where investment runs sometimes into hundreds of millions of dollars. Now, if there was no copyright protection for a film, we honestly would not be seeing any films being made, or at least there would be very short-form videos, and I think that would be a huge detriment to civilization, although you may say, Hollywood, forget it. There are plenty of other good films being made. Copyright is like a default system. It's not a sort of barrier. It's a default ownership system, which any copyright owner can displace at will, at least in theory. And I know there are plenty of arguments about the fact that in the academic world, it's not at will because you are forced into certain circumstances where you have to license your copyright or assign it. But in theory, it is a default system that protects that time and effort of the copyright owner. It's a voluntary system. You're free to disapply it if you wish. It's also the only tool we have against the pirates. And the pirates are out there, and the pirates are determined to make money out of other people's time, trouble, and effort. Without copyright, there is no tool to protect yourself from online piracy. Copyright is also a wonderfully simple system in its highest in its highest level. There are no formalities. The whole point of the Berne Convention was to create a type of protection for authors and writers and musicians which requires no form of registration. There are no formalities. You acquire copyright simply by virtue of creating something. Yes, there is a registration system in the United States where they all do things differently or slightly differently, but that registration system is there to give you advantages. It's not necessary for the acquisition of copyright protection itself. We have seen the UK government break up, according to some, the monopoly, or at least break it up further, the monopoly that copyright some people say copyright presents. Of course, it isn't a monopoly. There are lots of exceptions to copyright. It's not a monopoly in the sense a patent is a monopoly. So if two people come up with exactly the same song and they've never heard each other, and they've lived in different countries, never heard each other's music, both will enjoy copyright protection, even though the songs may be identical. It's not a monopoly in that sense. But we've seen recent introductions to exceptions in copyright law in the United Kingdom. So research and private study, the exception's been there for many years. That now applies to all copyright works. We've seen the recent introduction of the text and data mining exception. That's not a fair dealing exception. It's a specific exception to copyright law. And we've got a new exception for quotation. Now that must be fair dealing. And I think this is one of the questions we have to ask ourselves is, fair dealing, fair use. And I think the problem that law has, and always has had, is an attempt to be fair. And that is why the law is never too prescriptive, is because being too prescriptive results in unfairness. Now, you might say that not being prescriptive also results in unfairness. That's also true, but legal jurisprudence will tell you that in the end, being not prescriptive allows the law to be fairer on a greater number of occasions than not. So it's true that fair dealing is grey, and it's certainly greyer in the United States than it is here. And of course, the Cambridge University case against the Georgia State University was a dismal disappointment to many in the academic world because it made things greyer than they had been, arguably. We now don't know where we are in terms of the extent of the fair use exception, but it's certainly true, one of my colleagues said, that it is a wider exception in the United States, and it's more constrained here in the UK. But I think there is a great argument for being clearer as to the extent of fair dealing in particular sectors of industry and enterprise, and I think the academic world is one where certainly a fair dealing code would be a very, very useful thing to have so that everyone knows the extent to which fair dealing is possible. Yes, 2 minutes, right. Well, I suppose I'm nearly there, actually. I'd say, finally, to my mind, operating as a lawyer, actually, in the academic world, perhaps copyright isn't really the most important thing. In fact, I always say it to all my clients, don't get hung up on copyright. What's important are usage rights. You should only be interested in copyright itself if there's a capital value to the copyright, that possibly you could sell it on one day for a profit or for a sum of money. Otherwise, it's frankly irrelevant. What matters is the usage rights that you give or retain to your work. But moral rights are actually a completely separate matter to copyright. Certainly under English law, not true for our continental colleagues, of course, where they think of copyright and moral rights as being one and the same. But certainly here in the UK, it is entirely possible to divest yourself of your copyright, which is effectively a commercial right, but you cannot divest yourself of your moral rights, your right of paternity and your right of integrity, and so they march independently and separately, moral rights from copyright. And if we were to focus on the way in which moral rights are preserved and protected and don't get hung up too much about copyright itself, I think we might have a solution. Thank you.